Court does call the case of the People versus Vincent Dunlap. Good morning.
Good morning, yeah. Good to see you too, yeah.
Wow. All right, Mr. Bird. Yes, you know that.
This courtroom isn't off to a smooth start. When a defendant fails to show up, the entire process comes to a halt, and judges don't take that lightly. What looks like just a missed appearance can quickly turn into a warrant, or worse, additional charges stacked on top of the original case. For this first defendant, it's a shaky way to begin, and the judge's patience is already being tested.
All right, Mr. Bird, do you have a client?
Unfortunately, no, Your Honor. I did try and call him at his last working number. Madam Clerk did inform me that he was trying to contact the clerks earlier this morning, but unfortunately, he's not here.
I'll tell you what I'm going to do, Mr. Bird, because I'm going to adjourn this. Given the nature of the sentence, I'm not going to press one. And that there's been some contact. I'll just adjourn this out to our next date. I'll adjourn this to October 8th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome.
Your Honor.
Say I didn't do anything nice.
Never again, Your Honor.
All right.
You and Your Honor, go have a great day.
You do the same, sir.
All right.
Court calls the case People versus Kyle Beckerman. Go ahead, Mr. Burgess.
Good, thank you, Your Honor.
Here's where the case takes a critical turn. The defense argues for treatment over jail, painting a picture of rehabilitation. But probation reveals that Kyle has flat-out refused probation terms. In most courts, refusing probation is like slamming the door on mercy, because probation isn't punishment-free, it's accountability with structure. And without his cooperation, the judge is left with almost no choice but to lean toward a harsher outcome.
Good morning. May it please this honorable court, David Burgess on behalf of Kyle Beckerman. Judge, apologize. I had a logistical issue this morning with my associate, so.
That's fine. Your name, sir?
My name's Kyle Beckerman.
All right. Go ahead, sir. This is a date and time set for sentencing.
Your Honor, I've reviewed the pre-sentence report. It is accurate. Understand that the recommendation was for a year in the county. Based on the charge, it was a misdemeanor plea to use of cocaine, Your Honor. And last time we were in court, we were trying to get my client into inpatient treatment, and I believe the court allowed him to be referred. But I'm asking the court to consider either releasing him to treatment or giving him a time-served sentence. Judge, I know he doesn't have any means right now. He's homeless. This is somewhat of a victimless crime, Judge. So I'm asking the court to consider a time-served sentence or at least release him to an inpatient treatment so that he can get some help for the issue, the substance abuse issues.
Just clear.
Yes, Teresa Clare on behalf of probation. Your Honor, if the court is to consider a release to treatment, then probation would obviously have a different recommendation. There would be probation, a probation term that is recommended, so that could be monitored. When I met with Mr. Beckerman at the jail, he's very adamant with me that he would not comply with terms of probation. Therefore, probation did recommend the
Got it. Okay. That's why this sentence is structured in the way. It was based upon the defendant's comments.
Okay. I understand, Your Honor.
All right. Mr. Beckerman, anything you want to say before I close sentence?
I just wanted to pause.
This moment highlights the constant tug-of-war in criminal courts. On one side, the defense is asking for compassion, a chance at recovery. On the other, probation insists that the system already offered options, and the defendant rejected them. Judges are often forced into this balancing act. Do they gamble on a second chance, or protect the community from another failed attempt?
I apologize to the people, the court. Right now I can't do probation. I'm homeless. I have no income. I really have nowhere to go when I get out, so I don't want to waste the court's time. But I just wanted to apologize to the court and people.
Sentence of the court, $125 statutory fine, 365 days in jail, credit 51, defendant to serve the balance. Thank you.
Yeah.
Thank you.
Court calls the case, People versus Christopher Fair.
Under Natalie Pate on behalf of, but I do not with Mr. Fair, Your Honor. Today time set for a violation of probation. He is released from custody, and Mr. Fair and I did speak on the phone yesterday. I do not have an explanation for this hearing.
Teresa Claire on behalf of probation. Your Honor, given that Mr. Fair is scheduled before the court for a violation of probation, he's had multiple failure to appears in the past. And his presence not here today. Probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give a 10% privilege on that. That warrant issues immediate. Court does call the case, People versus Justin Duffany.
A packed docket exploded fast. One man begged for treatment, another refused probation, and 2 bench warrants hit the room. The judge drew the line, Dawn Farms for one, county time for another, and strict pay plans for the rest. Restitution set, date.
Notice the judge's tone here, calm but firm. Once a defendant refuses probation, the options narrow instantly. Judges can't force someone into rehabilitation, and without buy-in, the program almost always fails. This is why courtroom moments like this feel so final. The judge isn't just punishing, they're acknowledging that the defendant himself closed the door to alternatives.
It's locked, and one case dismissed after full compliance. This is where second chances meet the gavel.
Jail, he has used the time productively. He's gotten into the Dawn Farms program and also AA on his own initiative. I would ask the court to consider releasing him today and requiring him to find a treatment program. The recommendation is to complete the Dawn Farms program, and I believe that would take him another 3 weeks. But if he could be released today and told to go to another program, I'd appreciate it. I'm sure he would.
Is there anything you want to tell me before I impose sentence?
I just want to apologize for my actions with the bond and that I know that I screwed up. My priorities are in the wrong place. I have taken this time, got trustee, and I've been trying to help and better myself. And I promise you I won't be back in here.
Your Honor, if I could just add one more thing. He did have a prison sentence back in the 10, 12 years ago. After he got out in 2017, he completed probation, never tested dirty. So it's not like he's incapable of behaving when it comes to drugs and alcohol. And I just wanted to bring the court's attention to that.
Sentence of the court, 24 months probation. You're to pay $655 fine for court costs, $120 probation oversight fees. That'd be a probation payment plan that's paid by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-Dale Dawn Farm program, including all recommended aftercare. You're to attend 2 AANA meetings per week with verification to probation. You're to maintain employment with proof to probation. You're to contact probation within 24 hours of your release.
As we move to the next case, the courtroom energy shifts. Different defendant, different charges, but the same weight of judgment hangs in the air. Every person who steps up here is at a crossroads, and the judge's decision will either set them on a path toward recovery, responsibility, or more time behind bars. What you're watching is justice in real time, unfolding without a script.
Release from custody, and then report as directed. I'm going to follow, I understand what you're saying, Mr. White, but I'm going to follow what probation is indicating. I want him to be able to get a good start, because I think he can do it. I'm not really doubting that. He just needs the support around him to get him through.
Thank you, Your Honor.
I think Dawn Farms will do that for him. So I'm going to order 365 days in jail, credit 57 days that he served. He's to remain in custody, complete the Dawn Farm program, and then he will be released, and then the balance will be suspended. Okay, let's get that start for you. Is what I'm trying to do.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Vincent Lambert.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Lambert. Mr. Lambert was transferred from the Washington County Jail to Wayne County Jail. I could not confirm that he is still there, but that is what the jail told me when I went to see him.
Transferred from our jail to Wayne.
Yes.
So you don't know what to do with the case. You're just stuck with me here.
I'm just stuck with you. And without a client. So I asked for an adjournment to see if I can hunt him down. If he's still in Wayne County, obviously I'd contact the people to see if we can get a writ. If not, I'll try to get him here, but I haven't been able to have contact with him.
Given the nature of the sentence and what you're indicating, I'll adjourn it out. I won't issue a bench warrant to October 8th, 2025, 9 a.m. Court does call the case of the People versus Sean Costello.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Costello, who stands direct. Please state your name for the record, sir.
Sean Costello.
Thank you, Your Honor. It's my understanding that this is a show cause on the unpaid fines and costs on a closed case, Your Honor.
Is that what this is set for? It is.
So, Your Honor, unfortunately, it was after I left the jail yesterday that I discovered that Mr. Costello was in custody. It is my understanding he's being held on some other misdemeanor cases, with his next court date being October 9th. Given he's being held on those matters and I cannot make payments on the show cause in this closed case, I'd be asking for an adjournment of the show cause, please, Your Honor.
What he's being held on right now are all misdemeanors?
I believe that's what they were when I looked, Your Honor. Yes.
Give me a November date. We'll see.
Your first one, or your only November 12th.
All right. I'll adjourn this to November 12th, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Court does call the case of People versus Terrence Powell.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Powell. I don't see Mr. Powell here, Your Honor. I did speak with him. He said he has transportation issues. He couldn't get here in person because it is a VOP. Obviously, the Zoom request was rejected. So that is my only explanation for his failure to appear. He would like to request an adjournment.
This is where defense attorneys earn their stripes, trying to humanize their client in the final moments. They know the judge has already heard probation's recommendation, already seen the record. All that's left is one last plea, convince the court that their client deserves a chance at change. But in a room like this, with evidence and refusals already stacked, the odds are rarely in their favor.
So he can get here in person.
And Teresa Claire on behalf of probation, Your Honor, given that it was scheduled for a violation of probation, he is not compliant with his probation terms and he is not present. Probation is requesting a bench warrant.
Bench warrant will issue bond $25,000, 10% privilege. That warrant will issue immediately. Court does call the case of People versus Brian Gerard, all 4 cases.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Gerard. State your name for the record, please.
Brian Gerard.
Thank you.
Your Honor, these are show causes for money owed. Mr. Gerard has been in custody for almost, I think, 200 days at this point.
Gonna be for another 180 days.
His estimated release date next jail is February. I think February 6th or 8th.
That's my out date.
I think so.
Oh, that's great.
It's February 26th.
I think, I can't remember exact. It's February. I can't remember if it was the 6th or the 8th of February. I think.
That's 2026.
Exactly. Yes.
What's my last date this year?
Can I just pay? Can I stay here? Just let him pay?
You mean like get
December 22nd.
Yeah.
So here's what I'm going to do. I'm going to adjourn all of these to December 22nd, 2025 at 9 a.m. And Ms. Perrine, what I would suggest that you do is to file the paperwork regarding these fines and costs. It's
Okay.
going to be there's not going to be necessarily a reason to keep bringing him back.
Okay.
All right.
Thank you.
Thank you, sir. Court does call the case of the People versus. Ahmed Dico.
Go state your name for the record, please.
There we go. Got it.
Ahmed Dico.
Your Honor, this is a show cause. Mr. Dico has a balance, I think, around $1,200. I would ask.
I have it at 1443.
Okay. Well, worse, but I would ask Mr. Dico to advise the court what he can pay moving forward, please.
15, same amount.
Say that again, sir.
$15, same amount.
$15?
Yeah,
Why can you only pay $15?
because I'm currently unemployed. I was just being.
You're currently.
Yeah. Can you hear me?
I can hear you. All right. What I'm going to do is I'm going to order $25 per month beginning October 1st. I'll set a review of his payment. What was my December day?
December 22nd.
Review of payment December 22nd, 2025 at 9 a.m. And his employment should have improved by that point. I expect payments. Thank you.
Thank you.
Court calls case People versus Nicole McCauley. Both cases.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. McCauley. Ms. McCauley, please say your name for the record. Nicole McCauley. Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we do ask that you adopt the probation's recommendation.
Anything you want to tell me before I impose that?
I apologize about wasting your time.
I'm not wasting my time. I get paid. All right. In case ending in 0597, cents of the court, $125 statutory fee, $1,750 restitution to JSG payable through the court. I'll order 365 days in jail. Credit the 272 you served. The balance is suspended on that case. I'm presuming that after these cases, she's not going to be released.
Yes, these are the last things holding her. She's on probation in Wayne County.
Got it.
She's been on a writ here, but she's been in custody for quite some time. She was in Wayne County, then Oakland County, then back to Wayne County, then here.
Yeah.
So she's not working. So she's going to need some time to.
Yeah, the $1,750 I'll just make due and payable by December 31st, 2025. And so let her get out, get settled, and then try to make sure to try to arrange something regarding that. On the other matter, the case ending in 0111, on count one, the larceny, less than 200, I'll order $125 statutory fee, 93 days in jail, credit 93 served. On the count two, 200, larceny 200 to 1,000, $50 statutory fee. I'll reserve restitution for a period of 60 days. 300, and I'll order 365 days in jail, credit 272. The balance is suspended.
Thank you.
All right, thank you. Court calls the case People versus Michael Kyle.
Assistant Public Defender Natalie Kate for Mr. Kyle, who may be present via Zoom.
Michael Kyle.
Your Honor, I believe this was today set for state review, but I believe it was a show cause. I believe his balance is $360. The numbers I did have for him, unfortunately, are all now disconnected. I did send an email to the last email address I had for him, but other than that, I don't have further explanation for his failure to appear for the record request and adjournments.
Bench warrant will issue, bond 5,000, 10% privilege. Warrant will issue immediately. Court does call the case of the People versus Michael Patterson. Did they go back? What happened?
See before it's out, Your Honor.
They grabbed home. I would have held whoever.
I'm homeless. I can't do probation. The courtroom fell still. Rehab was ordered, bench warrants issued, and payment plans carved into the record. 25 a month for one, restitution by deadline for another. Some walk toward treatment, others back to a cell. In this room, every choice counts.
Sentenced to credit for time served. He states that he does reside at the Delana Center, and he is asking if Your Honor would allow him to be released today to go reside back at the Delana Center. Other than that, we would ask the court to adopt probation's recommendation.
Sir, anything you want to say before I impose sentence?
No, Your Honor.
On count one, indecent exposure, $125 statutory fee. Defendant is to submit a DNA sample. Although 365 days in jail. Credit 194 days served. Defendant is to serve the balance. On the count two, indecent exposure, $50 statutory fee, 365 days in jail. Credit 194 days served. Defendant is to serve the balance. Thank you. Court calls the case People versus Francis McMullen.
Teresa Clare on behalf of probation. Your Honor, Ms. McMullen was scheduled before the court today for hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation's recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
Hearing no objection, so
As today's cases show, courtroom justice isn't always about second chances. Some defendants fight for treatment, some walk away from opportunities, and others refuse to change altogether. Judges can only work with what's in front of them, and mercy without accountability doesn't last long. What do you think? Should a defendant who refuses probation still get another chance? Drop your thoughts in the comments. And don't forget, subscribe for more real courtroom moments, where every decision could change a life forever.